All right. John, do you want to start off?
Yeah. So good morning, good afternoon, depending upon where you are. We're really glad that everybody could join us here really on short notice. As I'm John Lucas and my partner Jim Stang here. Our firm is Pachulski, Stang, Zeal and Jones is counsel to the official committee of tort claimants in the Boy Scouts Bankruptcy Court. I'm sure most of you know. Last Monday, the Boy Scouts filed its amended plan of reorganization and disclosure statement and solicitation motion and notice of the disclosure statement hearing for April 17th of next month. It's the objection deadline is April 2nd. And we thought it was important to react here quickly and to provide a sort of a forum here where we could start discussing some of the issues that are that we see in the plan, and also provide sort of a question type format. So as things move along and Jim and I are sort of going through the plan and disclosure statement, we expect that many of you will probably have questions, and we will do our best here to try to either answer them immediately because they're right on point, or might delay them a little bit for a few minutes until we get to the appropriate part of the discussion and try to weave them in that way. And in the event that we don't get to one of your questions here, we will collect all the questions, and I think since we've contacted you all by email, we will do our best here to respond to you by email and follow up. This isn't going to be the last session. There will be, we assume here, town halls going forward as the case evolves. So I don't know, Jim, do you want to sort of kick it off? You're on mute, Jim.
Thank you. Good morning, everyone. My name's Jim Stang. John and I and Deborah Grassgreen and Rob Orgel at the Pachulski office are heading up the bankruptcy side of the representation of the Tort Claimants Committee. A couple of procedural matters that I think may be of importance to people. If you intend to file a pleading in connection with the bankruptcy case, other than litigation regarding your proof of claim or the filing of your proof of claim, of your client's proof of claim, you must associate with local Delaware counsel pursuant to Delaware local bankruptcy rules. The local bankruptcy rule is 9010-1. You can find it easily on the court's website. You can also find a separate note on the website under, I think, the attorneys tab regarding pro hoc vice applications. So you are required to associate with local Delaware counsel within 28 days after you filed your first non-proof of claim related pleading. I've been asked, well, what if I don't associate with local counsel? The rule requires that you do it. I don't know what Judge Silverstein would do with your pleading if you did not associate with counsel. I think in practice, especially if they're kind of joinders or me toos, the court doesn't police that rule carefully, but it is a rule and you should pay attention to it. The rule does say, except as otherwise ordered by the court. My experience with that provision is that I couldn't find a Delaware lawyer to associate with, so please forgive my failure to do so. But I want to make sure that people understand that Rule 9010 applies in this case, and you'll need to do pro hoc vice and association of Delaware counsel. The other thing that I wanted to mention before we get into a review of the plan and disclosure statement, but this message will permeate the discussion, is please work on amending your proofs of claim. At the present time, there are 83,807 non-duplicate abuse proofs of claim. By the way, these numbers are based on data that we are getting from the Boy Scouts that includes input from us and other parties as to critiquing how that data is presented. Excuse me for one moment. Have a slight cold and just needed a tissue. So take that, with a grain of salt, but that's the number. There are 39,177 proofs of claim that do not identify a local counsel. This is really affecting the TCC's ability to do its job in connection with the plan and disclosure statement. There are interactive maps on the Boy Scout website that would assist you in identifying the local counsel that your client was involved with. Please work on this. In addition, there are 7,186 claims that do not list the state or jurisdiction where the abuse occurred. This is, again, is really affecting our ability to do the best job we can on behalf of your clients. We cannot analyze the impact of the statute of limitations on the value of your client's claim, which is what the insurance companies are doing. It's what the local councils are doing. It's what the Boy Scouts are doing, if we don't know where the abuse occurred. And then finally, if you looked at claims within window states or claims that fall within the statute of, outside the statute, meaning there's no statute defense, there are approximately 24,000 claims. Now, that does not address the claims that are in states that we call notice states. X years from the date that you associated the abuse with the harm. But just pure window states and people well within the age range so that there's no statute defense.
Yeah.
Again, these are numbers provided by the Boy Scouts, and the more information you give us regarding your claim, the more we can look at these numbers and critique them.
In that number, about the number of claims that are technically in statute is probably a minimum or a low number. One of the things that, as Jim is mentioning about amending your proofs of claim, is making sure that the location of where the abuse occurred is in the proof of claim. And there was just a question about whether or not we're going to be sending out emails to people highlighting the things that need to be updated in their proofs of claim. And I answered that in the Q&A, but for everybody here, we will be sending those out next week. And so the location is essential. So for example, if it's not disclosed that the abuse occurred in New Jersey or North Carolina or California for that matter, it's just really essential in one of the levels of analysis of evaluating the claim.
And I just want to emphasize, this is information that we are getting from the debtor. We have been in touch with some people regarding this issue of omitted data. And the answer is, well, just look at the claim form. It's right there. We have not gone through 83,000 proofs of claim. We are relying on what the Boy Scouts tell us where there is missing data. So please, in that sense, give us a pass. If you get a note from John saying you're missing data on these 32 claims and you're wondering why we aren't doing our work, we're reporting back to you what the Boy Scouts have said. We will take your report if, in fact, the data is not clear. I mean, if you've answered the state and they're showing it's not answered, we will take your response back to the Boy Scouts. But this is something that we really need your cooperation on.
Yeah, and I think I said this in the last town hall, just to clarify what Jim is saying there. So if I send you, and the email actually might come from a sort of a generic, it might necessarily come from me, but my name will be in there somewhere, so you know it's from a Pacholski. But if I send you something and I say your 5 claims don't have an abuse location, and you come back and you say you were right on 2 of them, but you're wrong on 3 of them, I still want to know the answers for all 5. So if you could complete the spreadsheet and send it back to us so that I have all 5 at my fingertips, and I don't have to sort of wait through and sort of go through 85,000 claims and try to figure things out. It will really help us accelerate the review and basically our input and analysis of the information.
Okay, so let's get started on the subject matter of today's session, which is the plan disclosure statement and the motion to approve the disclosure statement, which I will sometimes refer to as the solicitation motion, because it deals with aspects of how plans, how voting will be solicited. So if you go to the Omni site, you will find the plan at docket 2293. You will find the disclosure statement at docket 2294, and you will find the solicitation motion at 2295. So 2293 through 2295. I just want to talk about deadlines for a moment. The deadline for responding to the disclosure statement is April 2nd. The currently scheduled hearing date on the disclosure statement is April 15th at 10 o'clock Eastern. The deadline for getting out, if the disclosure statement were approved that day, and I find it extremely unlikely that it will be, but let's just stay with the timetable. April 25th would be the deadline for the debtor to get the plan, disclosure statement, ballot, and other accompanying materials out to you. We'll talk today about what is in the disclosure statement and plan, but significantly, we'll talk about what isn't in there. This is not meant to be a definitive statement of what our disclosure statement objection would be, but we're going to touch upon some things. But there is a document called the plan supplement, which gives an enormous amount of meat to the otherwise bare bone of these documents. The plan solicitation documents are required to be filed by June 14th. The voting deadline is June 28th. I'll just point out that you're getting the package on April 25th, thereabouts. Important documents will not be in that package, or may not be in that package, because the supplement documents, which are critical, are due June 14th. So in effect, you're being given 2 weeks to make an informed decision on the voting, if in fact the solicitation package doesn't include the plan supplement documents.
And Jim, obviously, we're opposed to that timeline.
We are, yes. I'm just laying it out for folks. The confirmation hearing, which is the hearing for the court to approve the plan, is July 26th at 10 a.m. Eastern. So again, these are the deadlines the Boy Scouts have currently put forth. The court has not approved them. The Tort Claimants Committee doesn't support this plan. The Tort Claimants Committee doesn't support the adequacy of this disclosure statement. So these dates could move, but I laid them out for you so you can see, at least in terms of days in between X and Y, what the timetable could look like. So just a little bankruptcy background. The plan is the document that sets forth how all claims in the case are treated. It has not been approved by the court. It simply has been filed by the Boy Scouts. And if you see that it says amended plan, that is because the Boy Scouts on the first day of the bankruptcy case filed a plan that was even more skeletal than this one. They have filed a disclosure statement. A disclosure statement is a document that is supposed to contain sufficient information so that your clients can make an informed decision on whether to accept or reject the plan. The disclosure statement has not been approved by the court. It is subject to a hearing that is currently scheduled for April 15th. And when you read it, understand that this is the Boy Scouts disclosure statement. They did not negotiate the terms of this, the contents of the disclosure statement with the Tort Claimants Committee. I am not aware of them negotiating the contents with any of the representatives of abuse survivors. So when you read through the first 35 pages, including the full text of the Boy Scout motto and the Boy Scout oath, just keep in mind, this is their presentation. Whether that format stands up or not to the court, because they don't even mention the sexual abuse in any meaningful way until about page 35. I don't know, but read it with that grain of salt, understanding this is their disclosure statement, subject to the adequacy of information requirement that the code requires. The plan, and then you have the solicitation motion. That is they're all important. You really need to read that one because it goes through how creditors can vote on the plan. And we'll go through that with you. Again, it's a motion. It's not been approved. So that's what the TCC is doing, is reviewing these in detail, and will file responses and objections as appropriate. I do want to say that there are elements of the plan in terms of its framework that might be acceptable in a very broad sense. There is a trust established to administer the assets that the Boy Scouts are putting in and that the local councils and the chartered organizations might put in. That trust is supposed to take an assignment of insurance policy rights. That trust is supposed to administer how the claims are valued, which is a subpart of the trust called trust distribution procedures. So the concept of having a trust might be okay. Don't necessarily have to have a trust to do all the things that a trust normally contemplates. And those of you who might have been involved in asbestos cases may have some idea of what these trusts do and how they work and whether they work well or work badly. We just want you to know that the structure may be something that we can work with, but the terms and the specifics, to the extent they're presented, the creditors committee, the tort claimants committee, does not support the plan as it has been filed. So what I want to talk about is what the plan does with more specificity. I want to talk about the disclosure statement, and then I want to talk about the solicitation motion. And John will interrupt me from time to time, asking me questions. And John, if you're seeing a lot of questions on a topic that I'm not even addressing yet, we can switch gears really easily.
Got it. And some questions have come in, and I've been answering them in the Q&A. And as they continue to come in, I will either answer them in the Q&A or I'll weave them into our conversation.
Okay. So the plan of reorganization puts creditors into classes. The class for abuse claims is class 8. You should look at the treatment of the other classes because their treatment impacts how abuse survivors are treated, because value is going out to other creditors through the plan. But if you want to know what the plan says about abuse claims specifically, do word search class 8. Creditor classes are either impaired or unimpaired. Unimpaired means that the claim rides through and the plan does not affect the legal rights of the creditor. The plan does address the possibility of objections to claims, to classes of claims. The abuse claims are a little different. But in terms of what unimpaired means, it means the legal rights are not affected, and it means that class of creditors does not vote. You then have impaired classes of creditors. Those impairments can be consensual, like the impairment for JP Morgan, the Boy Scouts secured creditor. It can be a consensual impairment would be what the trade creditors are getting. And class 8, the abuse survivors are impaired. Impaired creditors get to vote. In order for the court to confirm a plan, at least one class of arm's length non-insider creditors has to vote yes on the plan. The bottom line is someone who's affected by it, at least some group that's affected by it, has to say we're on board. Voting is done by class. Each creditor gets to vote, but the court looks at the voting results from a class perspective. Voting is different than objecting to the plan. They're not the same thing. There are certain instances under the code when the court looks to see if a class has accepted or not accepted the plan. That is voting. But objections to confirmation are different. And in this town hall, we're probably not going to talk about the kinds of objections that can be raised, but we will schedule many more of these, and we will get into that as we get down the road. The Class 8 vote will be likely determined on the basis that each creditor gets $1 to vote. That is not the amount of your claim. That is not the amount that doesn't mean that everyone's going to get treated on a pro rata basis in any kind of distribution of money. But given that all of the claims in Class 8 are not reduced to a dollar amount on a creditor by creditor basis, I don't think anyone that I've heard of actually has a judgment against the Boy Scouts that would fall into Class 8. The courts in a mass tort context typically assign $1. So in effect, the Class 8 claimants, in order to confirm the plan for its treatment of the Boy Scout claims, not necessarily the local council claims or the chartered organization claims, but for the Boy Scout claims, requires of the people voting, underline that, of the people voting, not the 83,000, but of the people voting, requires at least 2/3 to vote yes. If the class does not accept the plan, but some other impaired class does, the court can still confirm the plan. That is called cram down. When a class that has not accepted the plan is nonetheless, where the plan is confirmed, notwithstanding the fact that one impaired class has voted no. Some people ask, would the court cram down a plan over the objection of the survivors? I can only point to the Catholic Church cases for guidance on this. And the answer is, we have had no history of a court confirming, cramming down a plan over the objection of abuse survivors. In the Archdiocese of Minneapolis case, survivors, the court considered confirmation of a plan that had a rejection by the abuse survivors, and the court did not confirm that plan, in large part because it said, this is what this case is about. There was 90+% rejection, and the court simply was not going to do it. There were other reasons, but that was a major reason. So the plan will tell you how the claims are treated. This is where these plan supplement agreements are critical. And of course, they haven't been filed. So the plan says there will be a trust. The trust will be assigned the property that the Boy Scouts are proposing to put in. By the way, we think that the value of the property that the Boy Scouts are putting in that will actually flow to abuse survivors is about $116 million. You have heard the number in the press that it's 220, that it's 200, it's 207. When you really grind down through what is available for the tort survivors to go into the trust, it's about 116 million based on our evaluation. But I want to make clear, that's not $116 million that's going to go to abuse survivors. That's 116 million that goes to the trust. And as you'll hear in a few minutes, when we talk about what trust distribution procedures could entail, there's a lot of administrative costs to running these trusts. So that is not the money going to survivors, that's the money going to the trust, whose function is to benefit survivors. The trust will get the BSA consideration. If the local councils participate, it will get the local council consideration. And to the extent any chartered or sponsoring organizations are participating, it will get that money as well. And property. These are not cash numbers. It could include cash and real estate and personal property. For example, the BSA contribution includes its Norman Rockwell Art Collection. So when we think about the trust, how it functions, the adequacy of the money of the property coming into the trust, please keep in mind, it isn't all cash. And that will be true for the local councils as well. It's clear from the disclosure statement that the Boy Scouts who aspire to have the local councils put in $300 million will include cash and property. And by the way, I don't remember the exact date, but I think sometime in early June, the Boy Scouts are scheduled to report to the court on how it is doing in herding the local council cats to raise that $300 million.
Yeah, and wait, Jim, can you sort of focus on that for a second? Because I think that you need to make that clear. So the $300 million local council contribution isn't agreed to as of today. Is that correct?
Absolutely not. No survivor group has even come close to accepting a $300 million offer.
No, but I think that the local councils themselves aren't even in agreement of making that contribution.
So we had a meeting with the local council ad hoc committee. They presented to us how they have been surveying and interacting with their constituents to come up to a number. The local council ad hoc committee has never made an offer. If you read the exhibit in the plan carefully, it tells you what the Boy Scouts hope to achieve. Now you can say read between the lines, but sometimes I don't read between the lines. Sometimes I only read what's written. The local council ad hoc local council committee presumably has discussions with its constituents as to who's going to put in what. We'll talk about the disclosure statement issues in a few minutes, but needless to say, it's not in the disclosure statement how much any individual local council is putting in. We think that's a very important piece of information. It's not in there at the moment. So this is, I call it aspirational, and maybe it's informed aspiration, but that's all it is right now. But I really want to emphasize that $300 million number has not been accepted by any group representing abuse survivors. So the trust go ahead, John.
I was to say, hey, Jim, there are a bunch of questions, and I know you're talking about, and this will dovetail into what you're talking about.
Well, we can jump if need be.
But this is, so Jim was just explaining that the BSA is going to put in a bunch of, cash and property, what we call sort of non-insurance assets. And so there are some questions about the insurance assets.
About to get to that. I was just about to go to it.
And so yeah, go ahead.
Okay,
and
so
start, and I'll maybe, if you don't sort of touch on the questions that a few people have asked, then I will interject. And
okay, to recap the insurance program, prior to 1971-72, BSA had its own insurance. It was the only insured, and the local councils had their own insurance. BSA was not a joint or additional insured. From 72 to 78, the local councils had the opportunity, but were not required to be a co-insured, joint insured, additional insured with the Boy Scouts. Post 78, the Boy Scouts enacted something called the GLIP program, General Liability Insurance Program. And as part of that program, it required that local councils be co-insureds on BSA policies. So you had pre-71, 71 to 78, and 78 and forward. So under the plan, the BSA is assigning its rights under the insurance policies to the trust. It contemplates that the local council's rights under their insurance policies, both jointly held with the Boy Scouts and individually held, will be assigned to the trust. In effect, not for all purposes, but in effect, for many purposes, the trust would become the insured and the Boy Scouts would not be. So that's the idea of moving the insurance over. The treatment of the chartering organizations is absolutely the most vague part of this. They don't have an agreement with any of the chartering organizations to deliver anything. And so when you look through the plan to see how chartering organizations are treated, it is very vague. But I would expect that if they cut a deal, or if a deal was cut with the Mormons or the Methodists, and those are the major religious groups, that it would include property, maybe just cash, and a contribution of insurance rights. Now, this idea of assigning insurance policies to a trust has been litigated in the bankruptcy courts because all insurance policies that I've ever seen have anti-assignment provisions in them. The current plan provides that it does not impact the rights of the insurance companies except for the assignment provision. And so that concept that a plan does not affect insurance policies is called insurance neutrality. And if you get into this plan process to any extent, you're going to hear a lot about, is the plan insurance neutral or is it not insurance neutral? So this plan by the Boy Scouts is intended to be insurance neutral, except to the extent that the policies can be assigned to a trust. There will be a lot of discussion and litigation about that. John, does that address the insurance issues that people were asking?
No, so Jim, more specifically, here's sort of, let's start with sort of more general on the BSA stuff. If there's an assignment of the insurance rights, how's that going to sort of play with the insurers, making basically a monetary contribution or a buyback? So how is that process sort of out, and sort of what's our sort of position on assignment versus negotiating buyback?
So think about the assignment as replacing the trust with BSA. And by the way, there are plans that provide there should be no assignment. Just let BSA continue to be the insured and work with BSA to negotiate a global resolution with a given carrier. So, but let's stay with the trust idea. The trust is now the insured. It has the ability, subject to protections that will be built into the trust agreement, to sell the insurance policy back to the insurer in exchange for presumably a lump sum of cash. So until that happens, coverage litigation is ongoing because the trust becomes the party enforcing the rights in the insurance coverage litigation. The claims will be valued one way or another. And maybe the insurance companies at some point will come to the table and say, we would like to resolve our entire risk on these insurance policies. Now, it gets a little complicated because there's excess to the primary and there's excess to the excess, and but that's not for today. But that's how it works. You're really just think of it as BSA being replaced. So claims litigation, claims administration, valuation is going on. Coverage litigation is going on. And if a deal can be cut with a carrier to resolve its risk under the policies, that's what the trust will be able to do. What happens to the claims who are covered by that insurance is an issue for the trust agreement and for the trust distribution procedures, none of which are addressed in this plan. So if you've got a claim covered by Hartford and Hartford settles its 10 years of exposure, and you want to know what happens to your claim, that you're out there through either the trust distribution procedures or some litigation that you're fighting, don't bother looking for it in this plan. It's not there. But we're working on how to deal with those claims. John, does that address the questions?
Yeah, and you just answered another one that just popped up.
Well, there you go.
You just answered another one that popped up. But here's another question, and I'm sort of breaking it into sort of two parts. So you were just focusing on the BSA insurance policies, but there are also the local council insurance policies. And so first thing I want you to raise is maybe the problems that the TCC sees with the assignment of the local council insurance policies. And then the next question is, um, if those local council insurance policies are assigned to a trust, is is this going to prohibit survivors and their counsel from prosecuting their claim in state court?
Okay, let's go back to the insurance program. Joint policies. And by the way, this could also apply to chartered organizations, but our immediate focus has been on the local council issue. You got joint policies and you have individual local council policies. I think that because of on the joint policies, that the court may have jurisdiction to allow the assignment of those policies, even including the local council's interest. That's on the joint policies. On the local council only policies, I think there's a more significant legal issue. And we have asked the Boy Scouts repeatedly, explain to us how you're going to accomplish this with the local council only policies. And we're not asking that question to try to stop that assignment, because the committee might decide that that's a good thing to do if people's rights can be balanced adequately as to their entitlement to indemnity, to payment under those policies. And we don't get it. We have not received anything close to a satisfactory legal explanation. So right now, we don't see how they're going to pull that off. Again, as to the local council only policies, as to the joint policies, I think there's possibly, there is a much better argument for bankruptcy court jurisdiction to do that. Whether the insurers think that that a plan can cover a non-debtor's assignment of an insurance policy, I'm sure they're going to raise that. But I think the court is going to be able to explain that one. Now, the plan ultimately will address, I'm now going to your second question, how claims are valued. My belief is that there will be a process that evaluates the claims in a non-tort system context. I call it, it's not a mediation, it'll be more like some kind of non-binding, or well, depending on your election to go into the tort system or not, it'll be some kind of arbitration-like process. And depending on the limits that might be paid for a given kind of abuse, the burden on the survivor will be greater or less. So for example, if a value of $100 is set to a masturbation claim, and you don't want to, your client's not prepared to put a lot more work into its claim, we might say the maximum you're going to get based on just the proof of claim, and I'm making these numbers up, folks, do not write them down. You might get maximum $30 of the 100. But if you're willing to go another step that looks more like litigation, maybe the maximum you'll get on that claim would be 60. And if you're prepared to go even further with discovery, which could be mutual, by the way, I'm not saying it's always on the survivor. It might be that BSA and the local councils have to respond to discovery. Then you could get $100. So that's what people refer to when they talk about trust distribution procedures. None of that has been negotiated. But when you look at mass tort cases, that's a concept that flows through all of them, that there's a matrix value, and depending on whether you want a minimal review or intensive review of your claim, your percentage of that matrix value could change. I also believe there will be the ability to elect to go back to the tort system and have your claims heard, adjudicated before a judge. There has to be reserves established, because obviously that process will take longer than going through this trust distribution procedure concept I described. But I believe that people will be afforded two paths. And there's a lot of detail that goes into what happens to the people who are in the, what we call the TDP system versus people who go into the tort system. And if you don't like what's happening in one, can you elect to the other? But that's all details that I think go beyond certainly what's been filed. None of this has been proposed in the plan, but I'm just telling you how this works out sometimes in a mass tort case. Okay, John, I'm going to keep going here. So that is what the trust gets, these various assets, insurance rights. What is it responsible for? What is it supposed to do? Well, I think we've gone a little bit into that today. It does a lot of things. It administers the claims, it handles the insurance issues. Under the plan, the trust is responsible for indirect rights abuse claims as well. And an indirect abuse claim could be a contribution claim by someone, a co-defendant who hasn't settled. It is responsible actually for that co-defendant's contribution claim. There could be indemnification claims. We've heard the Boy Scouts talk about whether they've indemnified the local councils and the chartered organizations. Those are indirect abuse claims. None of those folks have suffered abuse. Under the proposed plan, the trust has to account and be responsible for those indirect claims as well. Totally unacceptable, folks, but that's what's in there. The trust also indemnifies any of the parties who have settled through the plan. So if a local council has settled and it gets sued a year from now, the trust is responsible to indemnify that local council because that lawsuit would be in violation of the protections afforded to it under the plan. Unacceptable. There are lots of indemnification obligations that the trust has to bear. And then there are the administrative expenses of the trust. Think about reviewing 85,000 claims. Think how much that could cost even at a minimal review level. So under the current proposal, we think the trust is woefully underfunded. And that is a major problem with the entire plan. There just isn't enough money there to have this trust operate in a way that really serves survivors. Okay. The plan, as I said earlier, has no support from anyone except JP Morgan and what I call the Trade Creditors Committee. There's another creditors committee that represents creditors other than abuse survivors, the official committees. JP Morgan has a lien on all of BSA's real estate, not the local council, but BSA's real estate. Those are the high adventure facilities and its headquarters, and I think Scout University and its distribution center. And also has a lien on a lot of cash because, because it does. On the day that the plan was filed, there was an announcement that JP Morgan and the other committee and the debtor had reached an agreement regarding how JP Morgan should be treated and how the trade creditors should be treated. The JP Morgan debt and its mortgages have been carefully reviewed by the Trade Creditors Committee. And we believe that especially with the Summit High Adventure Facility, but not only with Summit, but primarily Summit, there is a real problem with JP Morgan's collateral. Under an order of the court, the Tort Claimants Committee has the right to ask Judge Silverstein to assert those rights against JP Morgan because they would otherwise be in the hands of the Boy Scouts. We have a standing motion ready to file. That's what we call this when we ask to step into the shoes of the debtor. We have a standing motion ready to be filed. We have a complaint ready to be filed. The settlement with JP Morgan does not settle this issue out from under us in the sense of taking away our right to ask for standing. We are still reviewing the JP Morgan settlement. It includes a reamortization of JP Morgan's debt. It includes, I think, an adjustment of its interest rate, and it does release some of its collateral for the benefit of survivors. But there are a lot of things it doesn't do. It does not release, for example, its security interest in the headquarters building. So we're looking at the JP Morgan settlement. When you go through the plan and disclosure statement, you will see a detailed discussion of it. So that has impact on abuse claimants, and it's something we're studying. Let's see. I think that's probably enough on the plan as an overview. Again, the plan supplement is really where the action is, and that has not been filed and won't be filed for a while if they keep to the timetable and use the maximum amount of time that they've allocated for themselves under that timetable. Just again, the court has not approved that timetable. We're going to push back. Judge Silverstein is currently presiding over a case called Imerys. It is a talcum powder mass tort case. It is about one step ahead of this case in terms of its reorganization process. We represent a significant party on the on the plaintiff side. We represent a significant party. We're closely monitoring and participating in Imerys, and Judge Silverstein in Imerys said that those plan supplement documents have to be part of the package that goes out to survivors or plaintiffs when they have to vote. So one of the things we have to do sometimes in these cases is take a deep breath and remember that this is what the debtor's trying to achieve. And there's an opportunity for a lot of reaction and response and discussion with the court. John, I'm ready to move on to the disclosure statement if the questions will allow me to do that.
Yeah, just one question here. I mean, there are some other questions here. I'm doing my best to answer.
Okay, well, let me move on to the disclosure statement, and if we have to, we can go back to the plan.
Well, here I have a question for you. So, just somebody brings up the question about claim estimation procedures and the current deadlines and schedule and timeline.
Okay.
Do those work together, or do they not?
This is a good segue for the disclosure statement, and I'll get to that question. I'll try to do it sooner than I had anticipated. The disclosure statement's purpose is to provide a survivor with enough information for it to make an informed vote to accept or reject the plan. It doesn't mean that every single fact about the Boy Scouts or the local councils or the contributing chartered organizations will be in that disclosure statement, because the court may find that that information, in her opinion, just isn't necessary to make an informed vote. And there's a reasonable standard thrown into there as well. The work that we have been doing with our financial advisor, Berkeley Research Group, has always been to understand all the assets and liabilities, to be able to negotiate with that information, but also in a sense to be ready for the day of reckoning on the adequacy of the disclosure statement. So we have spent an enormous amount of time getting ready to assess the adequacy of the disclosure statement. One of the first questions you think would be answered is, how much are the abuse claims? What are they totaled to? Well, we know the number. I can tell you, again, using BSA data, how many penetration claims there were, how many oral sex claims there were, how many masturbation claims there were, and whatever the tiers are in the proof of claim. There are certain assumptions made because people check more than one box, but with clear assumptions, we can tell you by local council, by year, by insurance company, where those claims fall. But no one has said in the disclosure statement, these 83,000 claims are worth X dollars. And that is an important thing to know, because when you're assessing your rights against BSA, your rights against the local councils, your rights against the chartering organizations, You would think that having that number would be useful. And while you don't know the ultimate liquidated value of your client's claim or claims, you'd at least like to know what the Boy Scouts thinks it would be, and maybe what the TCC thinks and other parties. The bankruptcy court is not allowed to tell claimant number one, your claim is $100. And that is as if the judge was the jury. Not allowed to do it jurisdictionally. The bankruptcy code prohibits it. And to underscore the point, a bankruptcy court cannot conduct a jury trial absent the consent of all parties. But what the court can do is estimate the value of a claim. And there's a discussion sometimes about whether the bankruptcy court can do it or whether you have to go to the district court, given the jurisdictional limitations. I'm not going to pay attention to that for this purpose right now. So the court can say, for purposes of determining the financial feasibility of the trust, the financial feasibility of the Boy Scouts going forward after plan confirmation, to determine if anyone is making a substantial contribution, that's the standard, to the plan. Is the local council putting in enough? But you got to know how much the claims are. And that's what estimation is. It's the court ballparking claims in different contexts. Could be by year, could be by local council, it depends what the court's asked to do. Could be window states or all states. The court can estimate the claims. It also tells the insurance companies that the court has estimated their exposure to be Y. Lots of case law on whether that constitutes a judgment that you can pin to the insurance companies and say, this is what you have to indemnify for, as opposed to it just being an estimate. So there has been discussion about whether it serves the interests of abuse survivors to have claims estimated. We're in close cooperation with the other parties representing abuse survivors about this. And it's also been the subject of discussion with the Boy Scouts. But I can't get into the specifics of it because it's all been in the mediation, but it is something that is being considered and addressed. So the disclosure statement is supposed to have a lot of things in it. And I found that this disclosure statement doesn't have most of what we're looking for. And so this is going to be a little bit of a list of what it doesn't have. And I'll try to explain what it does. But again, this is not meant to be a listing of all of the defects in the disclosure statement, but it's the stuff that comes easily, at least to our minds. The first is insurance information. Have they given us enough insurance information? Nowhere in the disclosure statement are you shown a coverage map. You don't see what the insurance is on a year-by-year basis. You don't see who the carriers are in that year. You don't see what their limits are. You're not told whether that policy was bought back. There's some that were. You're not told if the carrier, where there's insolvency by the carrier, I mean a formal insolvency proceeding. And some policies can be exhausted. I mean, they're not all of these are per occurrence policies. Some of them were aggregate policies. And some of those aggregate policies had a provision for deduction of defense costs in addition to whatever settlements there were. So some policies years are exhausted. Nowhere is that discussed. There is some very general language about how rich the insurance program is. And, there are, if you saw a coverage map, you might conclude for a given year or years that that's true. But those details are not provided to you. Likewise, there's no analysis of how many claims fall within a given year. And if we had even a range of values for claims, what the claim value is in that given year. So you can compare the value associated with a groping claim and see if it's within see what the deductible is or the self-insured retention, see what the primary policy is, And if it's a severe claim, say an oral sex claim, what the primary is to see if you can reach into the excess. None of that is provided. And we think that is an enormous shortcoming in the disclosure statement. And a little more nuanced issues, it does not explain what agreements exist between the Boy Scouts and the insurers as to how many occurrences are counted. If your client was serially raped between 1978 and 1981, how many occurrences are there? And do the Boy Scouts have an agreement? Or do the Boy Scouts have an ordinary course of conduct with the insurers as to how to count those occurrences? Obviously, if the policy is triggered once, that's important to know. If the policies can be triggered for each touching, that's a whole different analysis. They allude to it. It's called a first encounter agreement, which means the policy is triggered in the year of the first encounter with the perp and no other year. But it's not a good enough explanation given what we know about the insurance. They also spend very little time talking about coverage defenses. There are 3 lawsuits. They do talk about 3 lawsuits that are out there on coverage, but they only give a very, very light treatment of the coverage defenses. Now, one might say that if there's no deals with any of the carriers, how much do I need to know about that? Because the policies are being assigned, or the rights under the policies are being assigned. That might be a good point. But if there is a proposed settlement with a carrier, much, much more information is needed. And again, this relates to not only the joint policies, but to the local policies as well. We talked a little bit about claims value, but a lot of people have asked us, how many claims are there in Nevada, in Florida, in New York? Actually, we get asked about all jurisdictions. So hopefully by the end of today, we will have posted to our website, and we'll give you the website address, charts that show you state by state how many claims there are. And I'll just share with you, I think I've got this written down. This is the kind of information. California has, again, this is based on, I want to caution, when we talk about these claims numbers, especially if we're talking state by state, remember, almost 7,200 claims don't list the state where the abuse occurred. So there's an undercounting. When we talk about local councils, which council has how many claims against it, almost over 39,000 claims do not list a local council. That data that's missing is not reflected in the numbers I'm just going to mention as asides. This is partly why we said to you at the beginning, it is so important for you to go back and get this filled out. But just as an example, California has 9,346 claims filed against BSA for abuse in California. We have this broken out by local council as well. New York, 5,178 claims. New Jersey, 2,198 claims. And I thought I had jotted down some local council info, but I don't see it real quickly. But we are going to post for you a state-by-state list of number of claims, and we're also going to provide it to you by local council. But please, when you look at the data, and there will be disclaimers on what we're listing, this is undercounted because the proofs of claim are not complete from this aspect. And I know I'm sounding like a broken record on this, but I think you're starting to appreciate how important it is for you all to go back. Oh, here I got it. Greater New York Council, I did find it. 1,304 claims against it. Michigan, 1,440 claims. If I can read my own handwriting. LA Greater Council, 1,136. So it's significant. And we think that information is important for people when they're assessing what they're going to release under the plan. So let's see. We need more information from the Boy Scouts on their restricted assets. We have a lawsuit that is filed and pending in the bankruptcy court challenging the the BSA characterization of what is or is not restricted. Whoa, that was good. That was the Boy Scouts not wanting me to talk about this. Sorry about that, folks. I pulled out of court. Hold on for a minute, John. Okay. So we have a pending lawsuit as to the BSA's view of restricted assets. When you read the disclosure statement, you will see lots of things about its, quote, vital charitable mission. They seem to think that charitable immunity still exists in the United States. Our focus is on what are donor restrictions, and also to the extent that they commingled cash, restricted and unrestricted, their obligation, their duty to trace, to establish that the funds are in fact still restricted. The same analysis needs to be done for local councils, because local councils have restricted and unrestricted cash. They have restricted and unrestricted real estate. And so what we have done, and this is something that I believe we will be advocating for in the disclosure statement, we want you to be able to go to the local council where responsible for your client's abuse and see how many claims are against it, how much cash it has, how much unrestricted cash it has, the value of its campgrounds. We have done approximately 500 appraisals of local council properties. The Boy Scouts have done appraisals of approximately an additional 200. And by the end of this month, maybe early April, there will be a total of 700 appraisals of campground and non-campground property. We currently have about, I want to say about 450 to 500 already done. But those are approximations. We want you to be able to see on a given local council the appraised values of the real estate. Not every local council property has been appraised. We have some methods for attributing value based on the appraisals, and we want you to see that. We want you to see the membership trends, both at BSA National and at the local council level. We want you to see how much they're spending on payroll per scout. And as membership decreases, of course, those numbers go up because they're per scout numbers. We want you to see how they're adjusting their overhead or not adjusting their overhead, both at BSA and at the local council level. All of this being done to assess whether the parties are trying hard enough to get fair compensation to survivors. We are attempting to talk to certain local councils about our analysis. We're not getting particularly warm reception so far, but we are going to continue to try to present our view of their assets and liabilities so that they can understand why the $300 million contribution just doesn't cut it. So there's a host of other things about the disclosure statement that are inadequate, but I hope from this part of the presentation, you can get a sense of what our focus is going to be on. And again, I want to reiterate, we are working with the other groups representing abuse survivors to make sure the disclosure statement's adequate. And we are trying very hard to coordinate our efforts vis-a-vis maximizing value. And just as an example, a day or two ago, the Tort Claimants Committee, the Coalition, and the Future Claims Rep sent joint demands to certain insurance carriers who have aggregate insurance policies. And I can't get into the dollar amounts because that's part of the mediation process, but that's an example of where we've worked together to make demands on insurance carriers. It's extending into many other areas as well, but that's one concrete one that I can point you to. John, I'm ready to move on to voting and the solicitation process. So you want to interject some questions?
No, there are some other stuff here, and maybe we'll do some sort of miscellaneous thing at the end, but there was a question about how do I vote in the voting process? And
That's what we're about to get into.
I told the person that we would get to that.
Okay, by the way, I talked about this website where we're going to post this claims data, state, local council. Again, we're working on putting in some of our assumptions and some disclaimers because, as I said, this is based on BSA information. So it'll be up shortly. We hope by the end of the day, but it might be into the weekend. The website to go to find this data is tccbsa.com. tccbsa.com. It actually takes you to our firm's website, but to a particular tab, and you'll see it there. Okay, voting. So the disclosure statement's been approved. Right, it hasn't been, but this assumes the disclosure statement's been approved. And the debtor is now mailing out or sending out packages of the ballot, the disclosure statement, and the plan with maybe some additional materials to solicit votes. Someone has asked, will the TCC or other groups supporting survivors have a recommendation regarding how to vote? And the answer is yes. And right now, the solicitation motion says we can include a letter only if we are jointly proposing the plan with the Boy Scouts. So the way they fashioned it right now, if we're recommending against approval of the plan, they don't want that letter in there. But I have no doubt that Judge Silverstein will allow the TCC and the FCR, and I don't know what she'll do with the coalition, but I suspect the coalition as well. And I say that only because it's not a formal committee representing all abuse survivors, but I think she'll allow all three to communicate in the solicitation package a recommendation. And it might be a joint recommendation, or they might be separate letters, but we'll see. But I do not believe the Boy Scouts will get away with only including vote yes letters in its solicitation package. One of the big questions is, does my client sign the ballot? Can I sign the ballot? And how does that all work? So you may remember that some of you were allowed as attorneys to sign the proof of claim form. And some of you did. The court will allow attorneys to sign the ballots. So the first question is, who gets this package? Does it go to my client or does it come to me? You can inform the Boy Scouts that you want the package sent to you. And you won't get 300 packages. You'll get 300 ballots, but you'll get one plan and one disclosure statement. If you tell them to do that, if you tell them to send it directly to your client, they will do that. If you don't tell them anything at all, they will send it to you. And what they'll send to you is a list of all of the claimants that they believe are your clients. And you have to sign something that essentially says, yes, I represent them, and send it back to the Boy Scouts so that they can then put the right label on the envelope. One of the issues that we've got is, who are they contacting to determine this? It's a little frustrating, but some survivors have filed multiple claims with multiple attorneys. I think I've heard one instance from John that one person has as many as 8.
13.
13. These are not amendments. These are separate claims filed by different firms. Maybe there's a couple that's the same firm, but I mean, it's just, in this sense, to a limited extent, it's a bit of a mess. The Boy Scouts are assuming that the last filed claim is the person who's representing that claim for purposes of this solicitation issue. Anecdotally, we are hearing that's not true. So one of the issues we've got is, why are you assuming that the last filed is the right law firm? And, in a sense, we don't want to sort this out. The TCC doesn't want to be the one sorting out between 4 law firms who really represents this person. But there's got to be some method to ensure that the right firm is getting this solicitation package and the invite to either vote on behalf of the client. I'm sorry, to receive the package on behalf of the client, or to have it go directly to the survivor. If you do not respond to that directive, they will assume that the package should go to you. The solicitation motion says that if you are going to vote your client's claim, that you must represent that you have sent the client the plan and the disclosure statement and the other solicitation materials. Now, that's not clear in the disclosure statement, but when you read the motion, that is something you are representing you have done. You also, of course, are representing that you have the authority to vote your client's claim, and that it's an informed consent and all that sort of thing. I urge you, go back to your retainer agreements. Make sure that they specifically authorize you to vote the claim. And if they don't specifically authorize you to vote the claim, get it amended. We are hearing rumors that a sneaky strategy may be employed to question whether you in fact have the authority to sign the ballot. Just make the issue go away. Get the express authority to do it. Now, I don't know what else to say about it other than the last thing we need is BSA or the insurers or the local councils, if they see the voting is going against them, to challenge your ability to vote the claim if in fact you have it. So just make the issue go away, go back and check your retainer agreements and fix them. So you'll get this package. You'll be, if you're voting the claim on behalf of your client, you can fill out a master ballot, meaning, a spreadsheet with whatever requisite information there is about the claim, and there'll be one, and you'll just check, accept, reject, whatever you do. The ballot itself is attached to the solicitation motion, and you are asked to accept or reject the plan. If you accept the plan, you are releasing BSA, any local council, because right now they're anticipating all the local councils will be included, chartering organizations that are making the inadequate contribution, as yet totally undefined, officers and directors, affiliates, the creditors committee and its council, the tort claimants committee and its council. Please vote yes for that one in particular. And there are provisions that say excluding willful misconduct and so forth and so on. It's very clear, by the way, that this release does not include perpetrators. That's express. That group of people, what I'll call kind of the BSA group, and then the committees that are associated with the case, they're called released parties. And if you vote to accept the plan, you are accepting the release of those parties. Separate from the released parties are participating parties. I'm sorry, I said local councils and contributing organizations were released parties. They're not. It's the BSA team, if you will. Participating parties, and I apologize for that, are different than released parties. So don't gloss over this when you're considering how you want to vote. Participating parties are the local councils, the chartering organizations, the insurance companies who might be settling through the plan. And you will be asked to accept or reject the plan. If you're not prepared to release those parties, then I would think that you're going to reject the plan. There will also be a provision that says, I want to opt out of the releases for the participating parties. Now, this plan, if confirmed, could nonetheless override that opt-out. But the court will want to know whether you want to opt out of those releases in considering whether she's going to confirm the plan. So the ballots go back to the Boy Scouts. They will, Omni actually, it's the solicitation agent, the same one that runs the website. They will calculate them, they will file a report, and that's the voting process. Voting is an aspect of plan confirmation. As I said before, the court can confirm a plan over the rejection by a class, but the voting is an important part of this. Again, BSA for its treatment needs a 2/3 vote of the people voting. Lots of questions about what about the voting for all these releases, especially with the chartering organizations and local councils. There's no hard and fast rule on this, folks. In the asbestos context, 75% voting requirement to give those kinds of releases. But this is not asbestos. There's no statute that says what the number is. You'll hear anything from 75%. I never heard anyone suggest it's below 75%, but they're just using the analogy of asbestos. Again, no rule, no statute on this in the non-asbestos context. And I've heard some people say in excess of 90%. In the church cases, we have gotten near unanimity, but it's a much smaller universe of claims. And we'll just have to see how this plays out. So how many people are supporting the plan in the abuse class will be important to the judge to determine whether she wants to override the people who do not consent to these releases. But the plan does contemplate that she can do that. So, John, that is.
Hi, Jim, I have a couple of follow-up questions
Yes.
about voting. So, I mean, and I answered one of them, and just so that everybody's seeing it, there was a question about, can my client execute the ballot electronically? And my answer was, I'm not sure that that's set forth in the.
It is.
Okay.
It is. There will be an electronic voting platform.
Yeah, and I was going to say, and if it isn't, we'll make sure it is. The proofs of claim are allowed to be executed electronically, and this shouldn't be any different. And so the other question about notarization isn't required for your ballot. Just,
No.
a wedding signature or a legitimate electronic.
Well, John, let's stay with notarization for a moment. The solicitation motion does say that the Boy Scouts have the right to ask you for a power of attorney to vote the claim on behalf of your client. It doesn't say it's required, but it does say they have the ability to ask for that. So but you're asking me about wet or dry, I guess. I don't think they specifically address DocuSign, if that's what we're talking about, but we will make a note to ensure that that is something people can do.
Okay. Here, hold on a second. Just trying to stick to the voting stuff, and then we might go to sort of a potpourri of questions. Somebody asked the question, am I going to know what my award amount is when I vote?
No, you will be told how the claim will be valued. And if there is a matrix of claim values, you'll know that, but you will not know how much your claim, how much you're going to get in a check, or even how much your claim is going to be in a liquidated sum, and what percentage you might be paid of that sum. That will not be in the disclosure statement. And that's why some people think that estimation is important, because while that's not telling claimant number one how much they're getting, you can start working at least with averages. But it's a great unknown, folks. We don't have a single insurance settlement in the bag. And while we've made some offers to some carriers, it's a huge part of this. We don't know what a chartering organization will contribute, or how we would apportion a particular chartering organization's contribution to the pool. I mean, are we going to let everyone share in what the Mormons put in? Or will that be dedicated in whole or in part to Mormon survivors? So there are a lot of uncertainties about the sources of money. And so the claim amount will not be in your disclosure statement, and how much you're going to get on that claim amount, even if it were, will not be in the disclosure statement.
So there's a question here that when am I going to receive my ballot? And it's not until after the end of April. I think it's like April 25th or something like that.
Yeah, the solicitation packages will go out. Again, this is on their existing timetable, April 29th.
Yeah, and it has not been approved yet. And so,
none of this has been approved.
None of this has been approved, but nothing would get put in the mail before April 29th.
That is their deadline for getting it into the mail.
Okay. Let me see here. Here's a quick question I'll answer now. There's a question, and again, this is a little bit off topic, but just trying to sort of answer as many of these as we can. There's the discovery that was propounded by the insurers against 1,400 survivors, and it was a lot of focus on the coalition state court counsel of those survivors. And what's the status of it? And the status is that the court took both of those motions under advisement, and she hasn't ruled on them yet. We don't know when to expect a ruling, but as things stand now, I wouldn't be surprised if she maybe has an oral ruling at the March 17th hearing.
So let me just build upon that. And John, I think maybe we should talk about the preliminary injunction as well.
Just 1 second.
But let me just answer that question.
Yeah.
She has not ruled. John is right. The insurance, Hartford and Century, one of the two main primary carriers, or two of the main primary carriers, filed a response to the plan, I think the day after it was filed or 2 days after it was filed, and said to the judge, the plan's dead on arrival, quoting some people on the abuse survivor side. And judge, the plan and disclosure statement are so deficient, you really need to give us the discovery that you have taken under submission. So they got another a shot in on that. But we're just sitting here waiting, because so much of what her attitude will be about the survivor discovery, that's the 1,400 people, and the attorney discovery, that's the targeting to law firms, is going to inform some strategic and tactical decisions. But John, should I turn to the injunction, or you got?
Just I have a sort of a couple questions about. I've had some questions about, because we talked about claim amendments and how it's important to have as much information as possible in your claim. We've touched on sort of the missing things that we see in people's claims, and I've sort of generally answered that, if you have, other support, you want to put that in your claim. And so people are asking questions, am I going to get more for my claim because I'm willing to fight more, or to go to court, or to sort of take the extra step rather than just letting my claim sit there and let somebody look at it? It's sort of, there's a couple of.
Well, it goes to what I was talking about, which were generalities about how mass tort cases have worked. There are different levels of review, and the maximum values you can get will be dictated by the intensity of that review. And by the way, when I've talked about some discovery that might be taken, there are two-way streets here, folks. I'm not suggesting the burden was entirely on the survivor. So the answer is, you certainly would have, I would think, the opportunity to get more if you're fighting hard. But those classes of, what I would call convenience class, expedited review is a term often used above convenience class. Individual review would be what people often call the top tier. All of those would have, I would think, adjusted values because you're fighting harder. But those values and what the percentage difference is between those classes, and there might be even finer gradations, if you will, between them, it's still very much a subject of discussion. I really want to talk about the injunction for a moment, John.
Let's switch.
So there's currently a preliminary injunction in place that restrains you from prosecuting local council or chartering organization complaints beyond getting them filed and served. The Boy Scouts have asked for an extension of that injunction. They've asked for an extension of that injunction till I think it's late June. In negotiation, they asked the Tort Claimants Committee to stipulate to that, and we said no. We have asked them for more information relating to troop rosters and ensuring that those anything produced regarding troop rosters, which I assume all of you know what a troop roster is, be shared with all of you. And that, you know, they not limited to the Tort Claimants Committee seeing the troop rosters to identify a sponsoring organization and or to identify, you know, other information that's on the roster. It's not our job to do that. It's our job to understand it, but I should say it's exclusive. It's not exclusively our job to do it. If you want to sue a sponsoring organization, we're not doing that for you. You got to do that yourself. And that helps bring pressure, and we urge you to do that. But obviously, you know, we rely on you folks to use the information as you see fit. We don't have a deal with them on extension of the injunction. If we did have a deal with them, we probably wouldn't want to give them more than, say, 75 to 90 days extension. But we don't have an agreement. We are working closely with the coalition on this and with the future claims rep. It's been the subject of mediation. It's going to be the subject of a call today, later today with the mediators. But right now, we're intending to object to an extension of the preliminary injunction. We are preparing opposition as well as other parties. I would ask you, if you feel that this is an important issue, especially the aspect of, you know, conditioning the injunction on getting rosters, that you watch the docket, that you file joinders, and they can be, and if they're more than B2, that's great. But Judge Silverstein needs to understand the importance of getting this additional information as we are going into disclosure statement and plan negotiations. We believe as a committee that the way you get local councils to the table and chartering organizations to the table is to make them understand their liability. And we are experiencing a certain amount of ostriches with their heads in the sand. There are a lot of people who don't want to hear that their local council has X thousands claims against them or a chartering organization. And we need to get that message out because that's going to make them want to settle. How that settlement money gets adjusted, we'll see. But right now, we're not getting the numbers that we would hope to get. John, that's all I was going to say on chartering organizations. And we have at least 2 minutes of scheduled time if there are a couple of extra questions, but we can go over if people, till we have like kind of a critical mass leaving.
Yeah, so the deadline to oppose extension of the preliminary injunction is Monday, March 8th at 4 p.m. And so absent a resolution with that between the TCC and the Boy Scouts, the TCC plans to file an objection. Trying to see here, trying to do my best to answer questions here. You know, so just a general question, you know, about, you know, BSA has said over and over about how important it is to stay on its timeline. You know, it wanted to be out by June, and then it was maybe August, and now maybe it's the fall, you know, so, I mean, I'm not sure if, you know, the person's in question really is, you know, what's the cash situation like at BSA, and can their operation sort of sustain the bankruptcy, I think is the question. I'm not sure.
Well, I think we can answer. Again, folks, we get a lot of information that's under confidentiality orders, and so we'll try to do the best we can. The Boy Scouts have a threshold cash on hand number. Hold on for 1 second. Okay. The Boy Scouts have a threshold cash on hand number for unrestricted cash. We think that number is more than they need. And we have an analysis to support that. They can, not even a matter of just cutting expenses. We just think they are just don't need as much cash as they say they need. They have not sold a single asset in the case to date. Is their threshold number in concrete? We don't know, but I guess that's the best I can say.
All right.
But I will say part of the getting out by the summer is they want to try to get the attendance back up at the high adventure facilities. Obviously, at the local council level, they're trying to get their camps open this summer. Things seem to be a little better in the COVID world, but as someone pointed out to all of them, none of these vaccinations are applicable to people under 16. So I think there's a certain amount of, we need a certain cash on hand and we can't handle the burn rate. And there's a certain membership and participation aspect to getting out in the summer so that they can take advantage of the camping opportunities. I will say, John, just I know this is on topic at all. Please remember, folks, we have an upcoming town hall for your clients. And we would encourage everyone to have their clients attend that. And that is it next Thursday?
This Thursday. It is this Thursday.
At 5 o'clock.
At 5 p.m. Pacific time. And and so we will have sort of a general update. Obviously it's for survivors and also Survivors Council. Come one, come all.
Yeah, we're going to talk about the plan disclosure statement, but as you can imagine, a much higher altitude than today's call.
And so there's a good question here. So, I mean, a number of people have asked, I should say there's another good question here. There's another person has asked, about joining the TCC's objection to the extension of the preliminary injunction. And, how are they going to know when to join and stuff?
Check the docket.
Yeah, check the docket. Yeah. And, until you can check the docket, you don't have to check the court's docket, but you can go to Omni Management, and Omni has a virtual real-time docket there that you could check and refresh and see when pleadings are filed.
Right, and also if you're on ECF, you'll see it. You'll get served.
And so, there are just sort of a handful of sort of different sort of general questions here.
I'll tell you what, John, just so people can plan, let's have it 11:40 Pacific time, a 11:45 hard stop. Mm-hmm. And we can pick up these questions since people took the time to attend today.
Yeah. So to sort of, again, there's some general questions. I'm trying to sort of merge together some of these questions sort of about insurance. Like, how do you deal with, a bucket of cash and then a bunch of insurance policies? And then, like, how does somebody sort of figure out what it is that they're entitled to from either of those things? And sort of to sort of put on top of that, if there are policies that are out there that have, great limits, that is, there are no limit, there isn't an aggregate limit or the policy
Right.
limits, the claim limits are really sort of good for a claimant, what's going to happen if the policy's sold?
So we want the disclosure statement to give you the information so that you can evaluate your client's insurance position. And that's why we think a coverage map with the kind of detail I was talking about before is necessary. And that's including the given local council's insurance, because remember, the local councils had their own policies for decades in some cases. It's also why we want you to understand the coverage defenses a little better than the way they've laid it out. But if an insurance policy is cashed out, bought back, and $100 comes into the trust, we are negotiating. Well, the Tort Claimants Committee is considering how it wants to treat that money. Should, and this is just kind of the hypotheticals, folks, don't take this as a recommendation coming from my firm or from the TCC. Should 100% of that money go to the abuse survivors within those years for the distribution of that money based on the value you get out of the trust distribution procedure process, that kind of arbitration-like proceeding I was talking about, or that you might be seeking in the tort system? I mean, if the policy is cashed out, will you be allowed to continue your judicial review, or will you be compelled to come back into the trust distribution process? If you were litigating and say you beat a motion to dismiss and you're advancing your case, do you get a multiplier effect to what the TDP might have given you because you brought in part, you're partially responsible for the insurance companies coming to the table? And so if the policy is bought back, I think the likely result is that you're going to be brought back into an allocation system that will reflect, in part, this is my expectation, that it will reflect in part your rights in those insurance years. So it's uncertain at this time, and you are being asked to vote with a lot of uncertainties, but these plan supplement documents should fill out, at least in terms of process, a lot of that kind of information, because I don't know how else you could vote. Is it all going to go into the pot for those Hartford years? Everyone shares, regardless of whether they're in a Hartford year or not? Or do the Hartford survivors, if I can call it that, call them that, get some kind of preferred return on that money? And is there an extra preferred return for people who went out there and litigated? Because presumably Hartford will settle faster if it feels the litigation pressure. I mean, that's how this works, right? So the answer is those are the kinds of things people are talking about. It's probably the best answer I can give.
Let me see here. I mean, just a question about sort of, of the extension of the injunction, as a bargaining chip. Can we ask them to waive the statute of limitations? And I think that would be
not going to happen. Sorry.
a pretty hard ask.
Well, and part of it is, just to be clear, and I didn't mean to be kind of smart ass when I said not going to happen. The carriers have rights regarding the defense of these claims. And I can't imagine a trade-off with the carriers, or frankly, any of the others, but especially the carriers. I mean, they're not going to waive their statute defense. Just not going to. There's been too much focus on it in our discussions with them to think that that's going to happen in the context of the preliminary injunction.
Okay. Jim, I think that's about it here.
Okay, good.
And again, so we are going to have more of these sessions. There's one on March 11th, and at 5.
That's for the survivors.
Survivors, and obviously their counsel too.
Right.
And we will announce more of these town halls going forward. And as you'll see, I mean, we had one just last week at the same time. And we imagine that these things will pop up with more frequency because a lot is going on in the case. And if you have questions, please, BSA survivors at pszjlaw.com.
John, do that one more time, a little slowly, more slowly.
BSA survivors with a plural at P as in Paul, S as in Staying, Z as in zebra, J as in Jones, LAW.com. So I don't
All
know.
right.
I don't know how you got your name into the name of the firm, but
I don't either. Folks, thank you very much. And we look forward to hearing from you and participating with you in getting the best result for your clients. Thank you and take care.
thank you, everybody.